Ladies and gentlemen, I'm going to go on and call the committee meeting to order. I know Jimmy Pruitt's here. He's got a simple piece of legislation. We've got five. Representative Pruitt, you've got House Bill 244. Have we got? You ready? Yeah, go ahead. Representative Pruitt. Mike Schurz.
This is House Bill 244, and this is probably one of the most important bills we'll pass this year. We're changing the Georgia Environmental Facilities Authority to the Georgia Finance Authority, Environmental Finance Authority, and basically it's just changing the name so that it more appropriately fits with what they actually do, because they basically do finance, and they finance water and sewer, the reservoirs. They don't own or maintain any type of facility, so this fits perfect with their name, and name change fits perfect with what they do. The cost is less than $150, and I appreciate your favorable consideration. For no questions.
Thank you, Representative Pruitt. Any questions from the members of the committee? All right. House Bill 244 has been properly moved and seconded. All those in favor, please signify by saying aye. Any opposed, same sign.
Thank you, Mr. Chairman.
Belongs to Mr. Earhart.
Thank you, Mr. Chairman, members of the committee. This is House Bill 63, and it's, you should have the most recent substitute, LC 188219S.
All right, can you hang on 1 second,
Certainly.
Chairman Earhart, because we've got.
Yeah, I circled on your stack. Okay.
LC 188219S.
Yes, sir.
And so we're striking LC 188146.
Yes, that was the subcommittee's as passed. And I don't know what level of detail you want me to go into, Mr. Chairman. I think everybody in here today was in here. I'm sorry, no, Representative Lane was not. Not on the committee. Okay, was in the subcommittee hearing when I went by line, section by section. I can do that again if you'd like, or I can explain to you the difference in the substitute you have there and what I showed the subcommittee.
I think, Chairman Earhart, if you would just give us an overview
All right.
instead of going line by line and then discuss the changes, and if there are questions from the members of the committee.
There's one change, and I'd like to suggest one other with some further information. The subcommittee's past version had in section, let me make sure I get the section number right. That would be in section 2 on page 2. There was a section that read, as further express purpose of this act to implement the authority granted pursuant to Article 9, and it was basically referring to the constitutional amendment. And this is, we talked about this in the subcommittee. I've struck that paragraph, those 1, 2, 3, 4, 5, 6, 7, those 11 lines, and effectively what that is the retroactivity provision that we talked about. I think Representative Eiler actually said it best. Let's let them decide that in the court, both sides. I mean, I don't want to get in the business of us helping one side or the other in a legal dispute. So, with abundance of caution, I'm just going to suggest we strike that one section and go back to the the basic statute there.
Chairman Earhart, can you tell me what line that is again?
Okay, that on if you still have the as passed subcommittee. That would be on page 2, lines 42 through 49. That was that 46S substitute.
Okay. Subsection B.
Yeah, it would have been section B. Now, under section 2, page 2 of your substitute, there is no section B. It starts on line 28, page 2, as 3644-2. reads lines 20 through 41, which are the same as, and then there just is, start picking back up, is 3644.3. There is no Section B now, nor Section A, because there's no need for that. The final thing I'd like to ask, I'd like you to take a look at page 27, I believe it is, on your substitutes you have in front of you. Representative Powell had asked a question with respect to loopholes and things like that, and in going through that and trying to answer his question, I was somewhat concerned. Let me address that first, and then let me address what I think will go a long way to solve a specific issue that they're having in Canton right now. Also, he had effectively asked the question that let me find that section. Representative Powell, the line numbers changed in between. His question was on page 27. It's now line 939, and I believe if I characterize this wrong, Representative Powell, you'll let me know, where it says have no taxable property interest in such capital projects. And effectively, the way I understood your question was, what if they changed the taxable property interest to 3%, 5%, or went along to try to get around it? I have checked that out, and most of these are leases, and they can't really. My understanding from the best legal advice I can find is you really can't play games with the property interest on a lease like that, and they're much harder to get. I'm certainly willing to continue to look at that, but what they did suggest along those lines, so that they're in the lines of looking for loopholes, on page 28, this is effectively a retroactivity issue too. On line 984, where it reads, has issued or has conditionally or unconditionally agreed to issue. I'm going to ask the committee to strike on line 984 the words, or has conditionally or unconditionally agreed to issue. Just those 8 words. That you're going to hear, if he gets here, some testimony from, I believe the mayor of Canton, or is the mayor of Canton, is that who called, with respect to a pilot that's being discussed there. Once again, I don't want to get into the ability to create a loophole or a retroactive issue, and if we take those words out, that will solve that issue, Mr. Chairman, and that's really the only changes that are there. I'm going to ask if you'll amend it on line 984 to take those words out, or has conditionally or unconditionally agreed to issue, and then Section B in Section 2. I'll yield for any questions.
Chairman Earhart, would you go, just for the benefit of the members that were not on the subcommittee,
Sure.
It deals with tax allocation districts and pilots. Would you just give a brief overview of the reason for the legislation?
Okay. As you all remember, last year we passed a proposed constitutional amendment that the people of Georgia voted on. 52% of the people in the state of Georgia decided that this was the TAD legislation, the tax allocation districts, were an appropriate vehicle for certain economic development activities. As such, in the legislation that we passed, we did put the requirement that even if it does pass, that the legislature has to come back in and create a statutory enactment before any new TADs can go forward. That's what we're doing in this legislation. Effectively, we're reenacting the Redevelopment Powers Law. One of the problems with the Redevelopment Powers Law in its original form, or the form that had been created since 1983, was the broad definitional structure that was in there. Pretty much any piece of property in the state of Georgia could have been considered for a tax allocation district. I think what that effectively did is it created some abuses of the system. And in a lot of areas, Cobb County that I represent in specific, it created a lot of hard feelings and a lot of I think people took it too far, and effectively ruined a supremely valuable economic development tool. And what this legislation, I hope, is designed to do is to not only rehabilitate that, but to narrow those definitions. And you'll see all throughout this legislation, we've gotten rid of that very subjective and very general language with respect to what a redevelopment district is. I think we've added some things like the public purpose language. You know, if you've got a statutory enactment that benefits a private interest in some ways, then it's certainly reasonable to expect a return on the government investment in that. And we've added certain things like arts and cultural history. You can use this for green space acquisition, those types of things that will benefit the communities. I mean, and it's still not the taxpayer's risk. We're not spending any new taxpayer money on any of these things. It's only monies from the positive increment that are created. So it really is a win-win in that situation. And the third major thing that we did under this is that we took what I think is a responsible approach to the concept of paying back this debt early. Some of these can stretch out to 25 years, and if you extend them maybe even further, you want to make sure that you pay off that debt in the most expeditious way. And that's what we've done here, so that, you know, once you've satisfied the underlying payback that you're responsible for, that you have to take the positive increments and pay off the bonds, the interest on the bonds. And those are, Mr. Chairman, those are the basic premises that run through a 28-page bill.
Any questions from the members of the committee for Chairman Earhart?
Oh, and I'm sorry, Mr. Chairman. That's the TAD section. The final section on the last page is effectively pilots. Those somewhat different than TADs. Just in general, pilots are very, very similar, and they can take properties off the tax rolls, but they don't, at this current time, require the consent of some of the other political jurisdictions. In other words, one jurisdiction can effectively take the property of the school board or the county, or vice versa, or whatever, without even a consent. TAD's always had to have a consent of effectively all three taxing jurisdictions in most counties. This precludes that.
And if I may, I think we've had 5 pilots in this state. Is that correct?
That's correct.
And there's, I think, legitimate fear that now that people know what they are and how to use them, that they're going to grow exponentially.
I would assume so. And I think we need to. This is not precluding the ability to use a pilot. It's a restriction on a pilot. They're a great tool. I mean, I think you may hear from the commissioner here in a little while, and he'll tell you the benefits. But the idea that you do it without the consent of a taxing authority and take that off the rolls for 33 years is a little bit over the top.
I've got a question for you from Representative Morgan.
Thank you, Mr. Chair. Mr. Chair, could you expound a little bit more on pilots? I'm not familiar with that. Number one, if you could give an example of one, and then secondly, how might a local government have one of these?
Pilots stands for payment in lieu of taxes. The best example, Representative Morgan, is one right in your and my backyard with the city of Kennesaw. They were turned down for the Kennesaw TAD, and I mean I'll submit right up front it was an excellent piece of lawyering on behalf of those who represented the Kennesaw Development Authority. They found this pilot provision in the Georgia statute, and effectively what they do is they will lease that area to the Development Authority there, and unlike a TAD where it has the Cobb County School Board had to sign off and the Cobb County government would have had to sign off, and this works the same in every one, that required no buy-in from either of those entities. So when they did it, they effectively took $700,000 of, a significant amount of money off of the tax rolls that both the school board and the county commission had anticipated as revenue without any ability to have any say in the matter. I mean, it could work. I mean, I don't want to pick on the city of Kennesaw there, but what they're doing is strictly legal. I do think, though, as the chairman of the county said, it was somewhat outrageous not to gain the consent of the other taxing elected jurisdictions.
Chairman Earhart, is it fair to say that in a pilot that one taxing jurisdiction can affect the revenues of another taxing jurisdiction without the one being affected having any say or
Absolutely,
in what happens.
That's a perfect characterization. That's what they can do. Very much taxation without any representation for the people that are being represented by that area.
All right. If there are no other questions, we have 4 people that would like to speak on House Bill 63, and then we'll allow you to come back. Lamar Norton.
Thank you, Mr. Chairman. My name is Lamar Norton. I represent the Georgia Municipal Association. And to members of the committee, I applaud what Chairman Earhart has done. We are in full support of the TAD pilot legislation. We've had some questions about if the transparency as far as City of Kennesaw having to tell Cobb County. If it were in reverse, Cobb should notify Kennesaw, and we hope that that's been addressed. We have 21 city school systems. Certainly if something's going on where those school systems are affected, we would hope that that would be pointed out and early enough. There's been a lot of misinformation that GMA is opposed to this legislation. I've seen things in the press. I've had numerous emails. I've had some pretty nasty phone calls and some threats about we should get on board with this and quit trying to stop economic growth in this state. Couldn't be further from what GMA proposes. We don't survive without jobs, and we don't survive without small business in this state. And if we can use these great economic development tools, then that's to our certainly to our advantage. We think that it's good legislation, and we ask for your support.
Thank you. Representative Chambers, could you call the next name on the list?
Next would be Ken GRC.
Good afternoon. My name is Ken Blakely. I'm president of the Georgia Redevelopment Coalition, which is a group of organizations who are supportive of House Bill 63 in its current form. We think these are making changes and adjustments to the tax allocation process that are going to be very positive for the state of Georgia, and at the same time provide some assurances to those who had some concerns about the original language that was included in the Redevelopment Powers Law. There are more than 50 jurisdictions across our state that use tax allocation districts or will be using them in the future. And given our current economic situation, I don't think we have a better tool within the state to promote local economic development. So we would certainly urge your support of the current proposed amendment. Thank you.
Thank you. Ken Stewart.
Mr. Chairman, members of the committee, I'm here today to speak in support of House Bill 63 with the amendments that Representative Earhart talked with you about this morning. And specifically, I'm here to, in the hopes that we don't have further amendments to this bill, for the simple reason that economic development, or in economic development for the state of Georgia, we've got to have some tools really to work with. And part of the tool set that we have is offering up tax abatements, negotiating tax abatements with companies in a way that you would normally recognize typical negotiation. Most development authorities across the state work very well with their municipalities without conflict. Section 3 of this bill is very narrowly drawn really to fix a specific problem without impacting traditional economic development tools that we have. My concern is any attempt we might have to expand this or amend it could put us into a position that would be harmful again to what few tools we now have, particularly at the local level, and that gets to tax abatements that come about as a result of the negotiations. So I'm urging the committee certainly to pass House Bill 63 with the amendments that were just offered by Representative Earhart, and keep this in mind that if we do change this in a way that requires some negotiation beyond or approval beyond the way that it is now, we would be the only state in the country that didn't effectively have this tool to deal with. And I certainly don't want us to be affect the jobs and our capacity to increase jobs, particularly right now And we certainly don't want to be known the state that as the state that successfully shot itself in the foot. Mr. Chairman, I'm speaking again in support of House Bill 63.
Any questions? That's all. Thank you.
Thank you.
Chuck Warvington.
My name is Chuck Warvington. I'm Executive Director of the Gwinnett Village Community Improvement District, the largest community improvement district in Metro Atlanta. I'm speaking in support of House Bill 63 in its current form. Wanted to also offer my appreciation to the hard work of Representative Earlhart for tightening the restrictions for TADS and how it's used. Our CID is at ground zero of some revitalization efforts in the Jimmy Carter Norcross area. And I had some notes I was going to go through, but I'll change it for the sake of my oldest son is with me in the 10th grade. He's 10-year-old fourth grader, and as we were driving in here, I was explaining to him what I was coming here to do. And as we were driving by an old steak and ale that was boarded up in a 40-acre building, 159-acre site that's basically completely empty, I was explaining to him this tool takes those properties and puts them back in the competition of being redeveloped and being part of what we're trying to do in Gwinnett County, in the southern part of Gwinnett County. So I encourage you to take the current form of Representative Earlhart's bill, and it is very, very critical to Gwinnett. And I'm also speaking as a representative of Gwinnett County Board of Commissioners, School Board, the Chamber of Commerce, and the other CIDs as well. Thank you very much.
Thank you. Jeff Hubbard.
Thank you, Chairman Scott. I'm Jeff Hubbard, President of the Georgia Association of Educators. We are speaking in support of House Bill 63 as amended. We would like to thank Chairman Earhart for working with us to address our concerns. Now, I do have to be honest with you. GAE fought very hard against Constitutional Amendment number 2, but it passed. So we're here today to speak in support of the legislation that tightens the language of what constitutes a blighted and deteriorated area. We feel also that this language does do a lot to help curb the possible abuse of TAD policy, which could harm school system revenue. So done in the right way with common sense schedules in regards to paybacks to the school system, this could end up being extremely beneficial for our school systems in the long term. So we would respectfully ask a do pass. Thank you.
Thank you, Mr. Hubbard. Matt Hicks.
Good afternoon. I'm Matt Hicks with ACCG. Here to support House Bill 63 as it's been presented to committee, and specifically speak to the pilot section of the legislation. That section was addressed, as you heard earlier, or drafted to address a very specific problem and not impact wider economic development efforts. And we'd like to encourage you to pass it without any amendments. We do have Dan McCrae, who's a bond attorney here, if you have any specific questions about that legislation. And then also Jerry Cooper, who's the Cherokee County manager, who could speak to an example of the problem that's being addressed, if it's the will of the committee.
Thank you, Matt. I know that is Jerry Cooper the person that you had asked in the office be allowed to speak, or was it somebody else?
It was the chairman, Buzz Aarons, who's here at another meeting, so Jerry's here, yes.
We got a question for you. Representative Oliver.
Were you offering Mr. McCrae to answer questions, or is he coming up separately?
Offering, if y'all like to ask some questions.
I wondered if he agrees with Chairman Earhart's decision to remove that paragraph B on page 2, and in terms of making the legislation a little bit more neutral on the current litigation.
Why don't
I'll let Dan, and I think that's regarding the TAD piece.
Yes, sir.
I know he's prepared to speak on the pilot. I'm not
Okay,
sure if he's
well,
familiar.
I won't
TADs in.
press him for an opinion if he doesn't have one, but
Representative Oliver, do you want Mr. McCrae to answer?
if he has an opinion on it, yes.
Mr. McCrae, would you use the microphone, please? It's televised. We'd like to make sure everybody can hear.
But just to be sure, your question is about the deletion of the words in subsection E of
Yes,
the Pilot
sir.
Restriction Act?
As set forth by Chairman Earhart.
Right, and I'll say I am Dan McCrae. I'm just a lawyer. I'm here speaking just on behalf of myself, but I'm glad to be here and appreciate the work of this committee. The Pilot Restriction Act. Okay. Well, but again, we are talking about the Pilot Restriction Act, not the TADS.
We're talking about the TAD section and specifically whether it relates to the current ongoing litigation that's going on between Mr. Woodham and the Land
In that case, I'd have to say I don't have an opinion because I'm here about the pallet bond section.
Thank you.
Thank you.
Okay.
Jerry Cooper.
Chairman, members of the committee, my name is Jerry Cooper, the County Manager of Cherokee. I want to express our support on behalf of the Board of Commissioners, the Chairman of House Bill 63. I'll give you one specific example that raised some concerns for the county as well as the Board of Education. We had a retail shopping center at Highway 20 valued about $100+ million. The project is nearly complete. They were contemplating issuing a pilot bond without speaking to the Board of Education, Board of Commissioners, which therefore would have removed nearly $200,000 from the Board of Commissioners tax rolls, as well as nearly $700,000 from the Board of Education. As you can imagine, we became very concerned since we have a very good relationship with the cities and the county that they would contemplate such a move. But we are very supportive of Representative Earhart's bill and want to thank him for his hard work in that endeavor.
Any questions? Mr. Cooper, I know that Buzz Aarons, your chairman, wanted to speak as well. If he comes in while we're still working on this, we'll be happy to
Very good.
give him that opportunity.
Thank you, sir.
Any other members? Or is there anybody else present that would like to speak on this issue? Chairman Earhart.
Yes, sir, Mr. Chairman.
All right, Chairman. We have before us LC 188219S. Is that correct?
That's correct. I do want to let you know that I had, in consultation with Representative Powell, he has one further three-word, I believe, amendment that he and I talked about. I'm okay with that also. It's along the same lines of what I discussed on the other amendment.
If you would, let's go through the amendments one more time.
You have the substitute, which effectively amended the subcommittee version. That was taking out that section on the retroactivity and the TAD. That's already in your substitute that you have in front of you. The other two, well, I will speak to the one amendment, and then if Representative Powell has his, I'll let him explain that. I don't want to. What I'd like to ask the committee to do is on page 28, line 984 of the substitute you have, 8219S. In between or after the word issued, strike, or has conditionally or unconditionally agreed to issue. Now that will go specifically to the issue that Mr. Cooper just brought up, or any retroactive pilots that may or may not be out there. I don't want to allow any loophole with respect to that. The governments need to be able to communicate with each other on these. Was that clear, Mr. Chairman? 984, strike the words, or has conditionally or unconditionally agreed to issue. So you put a comma after issue, and then go on with the conjunction or which have been judicially validated.
So it reads, this code section shall not affect revenue bonds or other revenue obligations which any local government authority has issued or which have been judicially
Correct.
validated. So we would strike on line 984 and 985 the words or has conditionally or unconditionally agreed to issue.
That's correct, Mr. Chairman. And whatever Representative Powell has that he and I discussed, I believe that's back on the previous page.
All right. Let's, I mean, procedurally, I think that, were there any other questions for Chairman Earhart? All right. Do I hear a motion do pass on LC 188219S? All right. Is there a second?
Second.
All right. The bill has been properly moved and seconded. I'm going to recognize Representative Meadows to propose an amendment.
Page 28, the amendment is to strike. Discuss has conditionally or unconditionally agreed to issue.
It would be or has conditionally or unconditionally agreed to issue. All right. That amendment has been properly moved and seconded. All those in favor, please signify by saying aye. Aye. Any opposed, same sign. All right. Representative Powell, did you want to say something?
Yeah, I had an additional.
All right.
On line 939 on page 27. After the words no taxable property interest in, add the words any portion of.
Can you repeat that?
Yeah. After the words no taxable property interest in, add the words any portion of, so that it will read that have no taxable property interest in any portion of such capital project.
Are there any questions for Representative Powell about the amendment?
Good amount.
All right. So you're making that in the form of a motion?
Yes, sir.
All right. Is there a second? All right. It's been properly moved and seconded. All those in favor, please signify by saying aye.
Okay.
Any opposed, same sign. All right. Any other amendments or discussions on the bill? Representative Chambers? Oh, sorry. All right. We've got before us House Committee of Governmental Affairs, substitute to House Bill 63 as amended. It's been properly moved and seconded. All those in favor, please signify by saying aye. Aye. Any opposed, same sign.
Thank you, Mr. Chairman, members of the committee.
Chairman. All right, House Bill 413 has been removed from the agenda at the request of the author. So anybody who was still here, who was waiting on 413, it's Representative Hatfield's 413. Representative Dempsey. Representative Dempsey, if you're ready, we're ready.
Okay. Thank you, Mr. Chairman. I appreciate being able to come before you this afternoon. This is HB 227 that's before you. This comes to you because of a situation that arose this past fall through the Secretary of State's office when someone in protective custody needed to vote and wanted to vote, but was concerned about revealing their address, not only for their own personal safety, but for the safety of the shelter they were actually living at the time. It will allow individuals who have received a court-issued protective order, restraining order, or who are bona fide residents of a family violence shelter to keep their addresses confidential. This bill is already enacted in 33 states so far. It may be for someone who is actually in danger or afraid to vote, and that is not good for us. I mean, that is one of the basic rights that we have, and to have that taken away at that time, I think, is also very critical. It will allow them to register and vote in a safe environment without fearing for their safety. It will be allowed for 4 years with documentation being shown to actually substantiate that they do qualify and can be renewed in a 4-year cycle. It will not do anything but hide that information in the database that our Secretary of State is charged with keeping and which is available for public inspection. I am here to answer any questions as well.
Thank you, Representative Dempsey. Any questions from the members of the committee? This bill is the bill essentially allows someone who is seeking shelter or who has had to have a protective order issued to vote without disclosing their address to the public, where the offender would have access to it. Representative Butler.
I'd like to be recognized and make a motion.
Any other questions? All right, Representative Butler, I'll recognize you for that motion.
I'd like to make a motion we do pass.
All right. Bill's been properly moved and seconded. All those in favor, please signify by saying aye.
Aye.
Any opposed, same sign. Thank you, Representative.
Thank you, Mr. Chairman and members of the committee.
Representative Lane.
Thank you, Mr. Chairman and members of the committee. I bring you House Bill 72, and we filed a substitute to that bill, which is LC 210367S, which should be in everybody's folder. When this bill proceeded through the subcommittee, it was just had mainly one provision, which was to eliminate the requirement of the election of a county surveyor in every county in Georgia. Since that passed out of the subcommittee, the Secretary of State's office noticed some requirements that they have that requires them to appoint a county surveyor to certain duties, and they have amended the original House Bill 72 to just take out county surveyor out of their code sections and put registered surveyor in place of that. So it really doesn't do anything other than clear up language throughout the code, throughout the Georgia code, that refers to a county surveyor and just makes it apply to a registered surveyor. This came about, we had this a couple of years ago. This same bill was before this same committee. Some of you weren't on the committee at the time. And it came to me because the Glenn County county surveyor approached me one day and said, we don't really need to require an elected county surveyor in every county in Georgia. We don't really have many duties. So why don't you try to eliminate it? So I've been working on that since then. And this doesn't take away the ability of a county to appoint a county surveyor just like they appoint a county attorney or a county auditor or something else. It just removes the requirement that they have an elected county surveyor or appoint one in place of the elected one, and leave it up to the county to make their decision. That's simply what the bill does. I think there's some folks here who want to speak on the bill probably. So I'll take any questions right now, or I would yield to other speakers and then come back at the end of their presentations.
Any questions, Representative Lane? Representative Lane, I have a question. When did they come to you with this suggested language?
They came to me probably Wednesday or Thursday of last week. I picked it up from Legislative Counsel's office Thursday was our Friday. I picked it up from Legislative Counsel's office on Thursday. And so it came to me probably Tuesday or Wednesday. They asked me about it, and I read the their suggested changes, and told them that I thought that was good to clean that language out of those different code sections, and they did that, and I picked it up Thursday and filed it today.
Who is here to speak on behalf of it?
I think ACCG.
I'll yield to him.
Okay, go ahead, Todd.
I apologize for not signing up. Again, I'm Todd Edwards with the Association of County Commissioners of Georgia. ACCG asked your favorable support of House Bill 72. I think in many cases, surveyor, the role, position of elected office has become antiquated. Counties after this, if so is the will of the committee and the General Assembly to pass this law, still have an opportunity to employ full-time surveyors, and also they have the opportunity to contract with their private sector friends in this regard should such services be necessary. Again, ACCG supports this bill. And we are aware of the proposed changes, I believe, from the state, and concur with those as well.
But did the ACCG recommend these changes, or did the Secretary of State's office?
We did not recommend them.
All right. Is anybody here from the Secretary of State's? Can you speak to these recommended changes, please? Are there any questions for ACCG?
Thank you, Mr. Chairman.
I'm Michael Sullivan. I'm from the Secretary of State. When we had reviewed the bill, it had come to our attention that at least one part of the Secretary of State's duties had an advisory panel in which a county surveyor was a member of it. And obviously, if there is no county surveyor that's not elected, that gets difficult. So all that we had brought to Legislative Council and to Representative Lane was some language that simply said that it didn't have to be a county surveyor anymore. It could be any surveyor.
All right. So most of the language is striking county surveyor and putting in registered.
Yes, sir. The registered land surveyor is a professional license under Title 43.
Any questions of the members of the committee? Representative Lane, you're comfortable that there are no hanks and boogers in this?
Yes, Mr.
We've
Chairman.
gone from
I did read all the changes that the Secretary of State's office proposed, and it was simply removing any reference to county survey and replacing it with a registered survey. And I didn't see anything that made any other change at all. Okay. So I do support it and ask that you pass the substitute.
Any further questions of Representative Lane? Seeing no questions, recognize Representative Meadows for a motion. All right. Bill has been properly moved and seconded. All those in favor, please signify by saying aye. Aye. Any opposed, same sign. All right, we're going. Representative Manning. House Bill 171.
Yes, sir, Mr. Chairman, members of the committee. The bill has been before you all before last week, and it is now a substitute for House Bill 171, LC 284643S. I believe the bill has been perfected during this past few days to really get all the hanks and boogers out of it, I believe, or at least I believed that until I got here today. And I've got Bill Roing from Cobb County Attorney's Office that brought the bill to us, as well as the Lieutenant Mark Howarth, and also the Associated Press folks that all agree to the language in the current bill. And I'd ask them to come forward and speak to the changes that were agreed to.
Did you want to ask something, Representative Manning?
Do we have, Mr. Chairman, do we have another substitute? 4643S is the same one we were working on last week, wasn't it?
That's what I have. I think that's right.
I think
I don't.
I think that's the correct one.
That's the only one I've been given.
It's a substitute, I think, is the question. It's not another substitute.
Okay,
Is
thank
that-
you.
Chairman and members of the committee, my name is Bill Rowling. I'm with the Cobb County Attorney's Office. The reason we asked Representative Manning to bring this particular bill was related to information that Cobb County citizens were registering with Lieutenant Chenoweth and other agencies that have what they provide is crime information for their local community. Then he would then ultimately get a request from him to provide, in essence, his email list to other people under Open Records Act. And so those people that are registering, in essence, for county services to be able to provide it with county information were then subjecting their private information, being registered on this list, to being allowed to be able to be introduced out to the public under Open Records Act. Lieutenant Chenoweth might have some more information. We also have samples of the PINS information which is sent out regarding that. If you have any other questions for me or for Lieutenant Chenoweth.
Representative Chambers.
Mr. Chairman, these questions are going to be very similar to the ones we asked in subcommittee. Just for general comments, as you know, I've worked on the Open Records Act for a couple of years now, and it is very confusing. It's a mess. The statutes are. While I agree with Section 1, my personal opinion is Section 2 is already covered by current statute. And I've got some highlighted in two different statutes if the chairman is willing to look at that. But and what they told me in disclosing the information that they had in their last testimony, they were erring on the side of caution and probably giving far more information than is required by law in a format that is not necessarily required by law, too, if they go back to statutes. And I'd be happy to show that to them. And if we need to work on those statutes, Mr. Chairman, I would respectfully submit that that might be where we need to fix it rather than adding a new section.
Representative Chambers, you're certainly a member of the committee. I mean, we'll look at whatever you have to offer. And
if you may indulge, and I'd love for the county attorney to hear this as well, too, because this is every single government entity and subdivision, I think, interprets these statutes a little bit differently. And if the chair will indulge me, I would be happy to read this, or we can plug it in and put it on the screen, whichever is easiest for you. I'm not sure how to plug it in.
I'll let you read it, but let me ask this. And Representative Oliver, I know you expressed questions about this in the subcommittee. If it's the will of the committee to put in an open records bill, if you will, that addresses the code sections, and to, between now and the next legislative session, try to get some consistency in the language and how this should be addressed, I'll be happy to put that language in if that's something that members of the committee think we need to go through with. I do know there's inconsistency in the sections.
Yes, sir. Mr. Chairman, I do intend to pass or drop the same language that I had last year that never made it out of Judiciary Subcommittee, in the hopes that over the summer, in the interim between sessions, we can actually have a series of hearings on that legislation.
Okay. Can we get that appointed to this committee?
I requested that last time, Mr. Chairman, but unfortunately it's above my pay grade.
Okay. I'll talk about getting it in here. We do need to. The code should be consistent.
And I would be happy to have the author of the bill be a co-sponsor of that as well, Mr. Chairman. I certainly don't want to step on any of the good intentions that the author is working on behalf of the law enforcement. But like I said, I think Section 1 is absolutely needed because email addresses are not included in the exception right now, although there are other information data sets that can be redacted already.
All right. Do you want to read the code section?
I'd be happy to. Thank you. Under 50-1870B, it says specifically all public records of an agency as defined in this code section, blah, 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 shall be open for a personal inspection by any citizen of this state at a reasonable time and place, and those in charge of such records shall not refuse this privilege to any citizen. So in reality, when someone comes up and asks to say, hey, we want to see all your database on that, they don't have to print that out or provide it to them on a disk or floppy or send it to them in a data file. They can actually just pull it up on a screen and show them that it is available for personal inspection. If you go down into the code section, 2 more down at number D, it says, no public officer or agency shall be required to prepare reports, summaries, or compilations not in existence at the time of this request. And while that particular sentence is somewhat vague, unless the police department is compiling this information and making it a formal report either to the police chief or the county commission, this data set does not exist as a report and thus cannot be requested with an open records request as a report unless they are already compiling it as such. And then if you go on down to the bottom of that code section G, it says, at the request of the person, firm, corporation, or other entity requesting such records, records maintained by computer shall be made available where practicable by electronic means, including internet access. There is nothing, it also says, subject to reasonable security restrictions preventing access to non-requested or non-available records. So that statute right there says it's only where practicable. It does not say shall be provided by electronic means, and if there's a security concern by the police department in releasing that, they're protected under that. Now, the code section that the bill seeks to amend is 2 sections later, 50-1872, which already in that code section, if you go way down to the bottom, talks about the paragraph having no application to the disclosure by an agency of information in its records in connection with the agency's discharging or fulfilling of its duties and responsibilities, including but not limited to the collection of debts, et cetera, et cetera. And it says the disclosure is not subject to the disclosure of information necessary to comply with legal or regulatory requirements for legitimate law enforcement purposes. And quite frankly, in my personal opinion, and this might be somewhere where we need to clean up some language a little bit, getting a notification database to notify citizens of crime in their community is a legitimate law enforcement purpose. And it goes on and on about how to disseminate it and how to show it. So quite frankly, it also provides for litigation and court action if it's used improperly or if it's used for purposes other than just for open records inspection. This article shall not be applicable to any computer program or computer software used or maintained in the course of operation of a public office or agency. It shall be the duty of the agency having custody of a record to provide all other portions, not the entire database, for public inspection or copying, not shall copy, public inspection or copying. So the agency can really have a little bit of leeway here on if they just bring them in to look at it on a screen or if they put it to them on a disk and hand it over to them for solicitation purposes. And there are provisions in the Act already in statute for misdemeanors of a high and aggravated nature if this is used for inappropriate purposes, such as commercial solicitation. I'm through.
Representative Hamilton.
Thank you, Mr. Chairman. I guess this question is somewhat for Representative Chambers, and then I'd like to hear from the learned counsel. So what you're saying is that Section 1 really does all that's necessary, and I guess I'd like to hear from the attorney his opinion of if we only did the language change in Section 1 and did nothing with Section 2, why would that not satisfy the particular situation there?
Well, Section 1 does address the specific issue related to the law enforcement, the PINs, the electronic notification. Section 2 is actually an attempt to address solicitation of those persons and citizens who become recently signed up for utilities. Well, the other question that we're having and experiencing with our citizens is those people that sign up for water that are new to the community. They then sign up for water utility. We are then getting requests, solicitation purposes, for all new utility holders in the county, and then we provide that information to them. So I agree with Representative Chambers that Section 1 is the most critical part of this legislation, which addresses the issue regarding law enforcement and email addresses. Section 2 is addressing another issue.
Well, can you explain why that would be Section 2? What you're saying is why would that be subject to open records? It's basically the name, rank, and serial number of the customers of the county, isn't it?
Well, it's all those persons that would be new that would be to Cobb County, but also, yes, I mean that information would be subject to open records as we interpret the statute. Of course, if as we understand 50-1870, a public record shall mean any document, paper, letter, maps, books, computer-based or generated information. So if that information is collected and it's on a computer disk, and pursuant to Section G, we would be able to provide that information to them. So, but correct in the sense that Section 1 is the one that addresses law enforcement issues. Section 2 is the separate issue regarding public utilities.
Where practicable, it does not have to be by electronic means. Otherwise it would be shall be made by electronic means. So what they're having to do is go and make a copy of a report that technically is not being provided to everybody on the commission, and they're generating a report upon request and providing it at the request at a level that they don't have to.
It's on. She's not speaking. Representative Oliver, can you shed some light on this?
I know there's some folks in the audience that really understand these issues, and you may want to, I don't know if you had a sign-up sheet for this or not, but my questions previously have been, is this the first time we've identified email address as an exception? I think the answer to that's yes, and I just want somebody to tell me if I'm right or wrong about that. And then Section 2 is problematical to me because we do have other language about solicitation in the code, specifically related, I think, to police reports for solicitation purposes. And as I was, the abuse of open records for the purpose of solicitation is where I'm interested in correction, but I don't know to what extent the codes already address that. In general, there are inconsistencies in the code, and your solicitation in Section 2 may or may not be consistent with the solicitation prohibition on court runner type people. But, Mr. Chairman, there are some people that know the answers to these questions, I think, in the audience, and I think Section 2 raises more questions than it's worth. I think Section 1 may serve the purpose you wish to achieve.
It does.
It's an invasion of privacy. You've got misdemeanor provisions.
I think we have someone who is an expert.
1 second, please. Representative Powell, we'll let Holly.
Well, I would, as far as the appropriate place to put it and whether it may have some inconsistencies or overlaps with other statutory provisions, I think the non-solicitation that they are trying to address is legitimate because any community that has public utilities, whether it be water, gas, electric, whatever it may be, those are all open records as defined under the statute, and those records, not only the names and addresses, but the amount of the bills and the payment history of any particular customer. All of that is subject to open records request, and if there is some improper uses being made from a commercial standpoint, I certainly think if it's not already addressed in the code, it needs to be addressed. Now, whether it should be addressed like this, I don't know, but I do know that that is a legitimate exception to the open records.
Thank you. Have we got anybody else that would like to speak on this issue?
Yes, sir.
Hi, I am Holly Mannheimer with the First Amendment Foundation, and many of you know that's the Open Records and Meetings group, and I've worked with Representative Chambers and others on the panel. We don't have an objection to Section 1, but Section 2 is problematical for all the reasons raised by Rep. Hamilton and Representative Chambers. Let me tell you in short the 3 reasons why we think Section 2 doesn't work, and then I'll try to answer some of the specific questions raised by the panel. if you look at the language as it's written, it says if an agency has reason to believe such information will be used for commercial solicitation purposes, that gives the agency the ability to ask you as the requester, why do you want this stuff? That kind of flies in the face that every good improvement you did for the benefit of the public does for open records. That bothered us. Just if an agency believes or thinks that somebody's asking for it for X or Y reason and they don't like that reason, they get to say, see ya, you can't have the data. Two, and there's been some discussion about this, the way Section 2 is written is it's overbroad, and we've got some concerns, and I hate to jumble this up with legalese, but overbroad from a constitutional sense is it ends up sort of covering too much or too little and is ill-defined, so we're sort of concerned even if it does passes, somebody will bring a challenge kind of wanting to strike it down. Last point before I answer the specific questions, though, there is federal legislation called informally the CAN Anti-Spam Bill that actually addresses exactly what Section 2 does. So there is language in the state code as well, but the federal language does exactly what it is that Part 2, I think, is trying to do. So in short, and then I'll answer that specific question, we're happy with Section 1. If that's what the committee would like to do, we certainly have no objection. Section 2, for all these reasons, poses problems to the First Amendment Foundation. Representative Oliver's point about anti-solicitation language in the Open Records Act, and I'm embarrassed to tell you I know off the top of my head, it's 50/1872 little a 4.1, and in 1999 you all passed this legislation to get at ambulance chasing lawyers, saying we didn't want them running down to the courthouse to get copies of motor vehicle accident reports, and that's the language that's already in the Open Records Act that speaks to solicitation. So I think that answers the question. But Representative Chambers, you're right when you say electronic records shall not be available where practicable. Email is sort of behind the times when we're, as you know, the law always follows technology. So this is one of the, that's why we're not objecting to Section 1. It makes sense. But anyway, I hope that answered some of your questions. So in short, we would oppose Section 2 of the bill.
Representative Manning, can I ask you a question? Does Section 1 solve your primary need?
Yes, sir.
It does?
Yes, sir.
All right.
The other section was an attempt to do, as Bill said, that we thought it was probably a good idea while we were there, but
okay.
Section 1 is really what we're after.
We've got about 20 minutes left in committee, and we've got other bills. I'm going to ask if Section 1 solves your immediate need and your primary need.
I believe it does, sir.
Okay.
Yes, sir.
All right. Representative Oliver.
Do pass, and then I'll offer an amendment to delete Section 2.
All right, LC 284643S, Representative Oliver has made a motion do pass on the committee substitute House Bill 171. It has been seconded. Representative Oliver has indicated she has an amendment.
I wish to amend LC 284643 by deleting Section 2, lines page 120 through the end of the bill, page 228.
And renumbering accordingly.
26, and renumbering accordingly. Yes, sir.
All right. All right. Is there a second on that motion? All those in favor, please signify by saying aye. Aye. Any opposed, same sign. All right. We have before us Governmental Affairs Committee substitute to House Bill 171, LC 284643S as amended. It has been properly moved and seconded. All those in favor, please signify by saying aye. Aye. Any opposed, same sign.
Thank you, Mr. Chairman. Members of the committee, appreciate it.
Thank you, Representative Manning. All right.
We amended and passed the bill out.
We struck Section 2. I'm sorry, I didn't see your light on. Oh, that's you, Representative. We struck Section 2 and moved the bill to rules. All right. Has Representative Lindsay made it? Okay. We previously had House Bill 82 before us. All right. House Bill 82 is currently on the table in this committee. I'm going to recognize Representative Meadows to make a motion so that we can continue debate on that legislation.
Mr. Chairman, I'd like to move that House Bill 82 be taken off the table.
All right. It has been moved and seconded that House Bill 82 be removed from the table, which will be back in the full committee for discussion. All those in favor, please signify by saying aye. Any opposed, same sign. All right. House Bill 82 is back in the committee. Representative Lindsay.
Thank you, Mr. Chairman. Please, the committee, I think you have before you a proposed change. And basically what it does is we attempted to, after talking with several members of the committee, deal with the concern folks had regarding the governor ability to appoint the Inspector General without sufficient oversight by the legislature. And basically what we have done here is that the governor has to make the appointment with the advice and consent of the Senate, which is in conformity with other folks in our state, such as the Office of Child Advocate. And someone can help me. Where exactly in that bill is that change?
This is LC 293755S.
Yes, sir. Yes, sir. And it's line 39 through 42 is where we made the change. I believe that fits with some of the concerns that were raised by some of the members of the committee, and we felt that was a good concern that needed to be addressed. Let me reemphasize that this bill, I think, is particularly needed in our state when it comes to trying to root out any corruption and we have some specific concerns now because this office will be charged with overseeing and making sure that the money that's being spent as a result of the federal stimulus package is being spent properly. And this is going to be one of the charges of this office to basically oversee and make sure that this money is being properly spent. And so I think we're all interested in seeing to it that money is being spent for the purposes in which it was intended. So I want to reemphasize that point. Also emphasize the point that once again we have a sunset provision in here to sunset this bill. Also, we have a new governor that will be elected in 2010, and underneath this bill, that governor will have the power to make an appointment of his or her desire in terms of who will be filling this position, once again with the advice and consent of the Senate. Those are the major changes, Mr. Chairman, from the bill as previously outlined to you.
Any questions of the author on House Bill 82? All right. No questions. All right, I'm more Representative. Okay. What number are you? Representative Chambers.
Appropriate time, Mr. Chairman. I'd like to move do pass on LC 293755S.
All right. Bill has been moved. Is there a second? All right. Bill has been properly moved and seconded. So the motion is do pass on LC 293755S, which is Governmental Affairs Committee, substitute to House Bill 82. All those in favor, please signify by saying aye. Any opposed, same sign. All right, we got one no. All right, we've got Representative Powell and Representative Ralston. 478.
Thank you, Mr. Chairman.
Wait a minute. I'm sorry. 294. You need to go next.
Thank you, Mr. Chairman. Is it okay if I do it from here?
Yes, sir.
I appreciate that. They're calling me from across the street to come vote in another committee. I'm here today, Mr. Chairman, members of the committee, on House Resolution 294, working off of sub 4681S, which just cleaned up some language. This came before a subcommittee last week, and all it does is correct
an oversight in the law that was made a few years ago that left off of the listing of county officials the office of coroner. It does not apply to those counties which have abolished the office of coroner. In other words, it only applies to those coroners that are still in existence by virtue of a local act, and where they're actually we're still electing them even though they're not on this list. And in many rural counties in particular, they're providing a very valuable service. There is no financial consequence to this bill, and it would have to be voted on by the people of Georgia to put them back on, and I would ask the committee's favorable consideration. And I think we had one or two coroners here today if the committee wanted to hear from them. I see Ted Bearden from Dawson County, and I can't see all the others over there. I know there's some others over there.
All right. We'll let anybody speak on that want to speak. Representative Butler.
Representative Ralston, I kind of thought this was a dead issue.
Well, for you and I, we haven't needed one yet, Mr. Chairman, so I guess it's still a live issue for those of us that are here today and still sitting up straight.
Representative Powell.
Thank you, Mr. Chairman. I just want to be sure that since right now you have a lot of counties that have abolished that position, if this passes, this will not prohibit counties and their legislative delegations at some point, if they see fit to do away with that position. It won't affect that will it?
No. I don't think it would. I think you could still go through. Would take a vote, a local vote of the people, I think, to do that then. But this would not prevent counties in the future from abolishing the office.
Mr. Chairman, if there's no other questions, I'll be glad to make a motion.
Hang on, I've got I do have a question about this. I got two here stapled together.
That's just what happened in the copy room. It's the same there.
Okay.
Somebody else can
Representative Ralston, if this passes and if it were ratified by the voters, you still believe that through local legislation you could abolish the office of the coroner?
It would be my opinion that you could. I think what you and legal counsel can correct me if I'm wrong. I think that what you would have to do then is have a local bill that were then approved by the voters in the jurisdiction that wanted to abolish.
All right. Legislative counsel agrees with you.
Okay.
All right. Ted Bearden has asked to speak, and then Jim Grubiak has asked to speak on this as well. Is there anybody else that would like to speak on it? Ted Bearden. Representative Jay Powell, did you have a question before we?
I'll ask the sponsor in a few minutes.
Mr. Chairman, members of the committee, thank you so much for allowing us to be here. I'm Ted Bearden. I'm the coroner of Dawson County and the immediate past president of the Coroners Association. And we would kindly ask your favorable look at this bill. It was something that was accidentally left off when the Constitution, going all the way back to 1777, only mentioned two positions within each county. One was the sheriff, one was the coroner. When the Constitution was rewritten in 1983, the coroners were accidentally left off of it then, and we're just simply trying to correct something there. As Representative Ralston has said, there is no monetary consideration there because we're not asking for any pay increase or anything of that nature. There may be, in a few cases, some counties that may have to pay insurance benefit or something of that nature to their elected their elected coroners, but by and large, the majority of the counties are doing that anyway for all elected officials. So there's really not a monetary consideration here from the coroner's point of view. We would ask your favorable consideration.
Can I ask a question there about the benefits? In a county where it was a part-time position, would the counties be required to pay full-time benefits of health insurance, and
I kindly disagree that it's a part-time position. We're elected to be on call and to be available 7 days a week, 365 days a year. That is a full-time position. We get up at 2 o'clock in the morning when everybody else is asleep. It's not a part-time position. It's a full-time position. The problem and the reason that the perception is out there that we are a part-time position is because the pay is so low that most coroners, just to survive, are bivocational. They do the coroner's work because they have a love for their community and want to do that. But I can assure you it's a full-time position.
well, we could. I mean, this. I think everybody here would say serving in the House of Representatives is a full-time position as well. But you would agree that in certain areas the coroner is full-time with full-time pay and benefits. Is that correct?
That is correct. There are some larger municipalities where the caseload is so big it requires a full-time.
And my question was, in the smallest counties of the state, if you will, then, does it mandate benefits?
That would be up to the local elected officials in that particular county.
Okay.
This would be my understanding.
All right. Representative Powell?
Understanding that this may have been inadvertently left out of the latest draft of the Constitution, if this has no monetary impact other than the prestige of being called a constitutional officer, why would there be the push to put this back into the Constitution?
Well, we'd just like to rectify the mistake, number one. Number two, there is a provision in the Code of Georgia in Title 45 that says if there is ever a time that an elected sheriff cannot or fails to act, then it becomes the responsibility of the coroner to do that. We feel that it's a little bit ludicrous to ask a non-constitutional officer to fill the shoes of a constitutional officer. Also, anytime we make a decision, when we're working an investigation, whether or not we're holding an inquest, anytime that we are asked to perform our duties, we are representing our counties. We are an elected official representing our county, and we just feel like there is some credibility, additional credibility there if we are a constitutional officer.
Yeah.
Thank you, Mr. Chairman. I'm Jim Grubiak with ACCG. I do have concerns with this proposal. But to answer your question, Mr. Chairman, I don't think there'd be any requirement for benefits for a part-time coroner. You know, the employees and staff can be distinguished based on some reasonable criteria, and I think part-time it could be enough to not force them to pay benefits. I just want to be clear about that. But by and large, we don't see any reason for this constitutional amendment. I guess maybe county commissioners were left out accidentally in 1982 also, but county commissioners are not county officers, and they operate quite effectively within the local governance system. So there's really no need to be a, quote, county officer in order to function. The coroners are elected officials. There's nothing proposed to change that, so I don't think there's any real need for it. Moreover, I think establishing coroners as a county officer, in other words, adding them to the list of the existing county officers, the sheriff, probate judge, clerk of court, and tax commissioner, opens up a whole can of worms. First of all, I would say that just compare the coroner, which really is a part-time position in most cases, despite what you just heard. It's a fee-based service. Compare that to the sheriff, probate judge, clerk of court, and others who are truly full-time elected officials. But counties, as you probably know, are saddled with this archaic system where we have semi-independent entities within the county that the county commissioners are responsible for. By that I mean the county commissioners have to levy the taxes to pay for the operations of all the departments of the county. And that, of course, includes those that are the semi-autonomous ones like the sheriff, probate judge, clerk of court, and others. But significantly, they don't have any management control over those positions. If you think back to last year when it was in the news quite a bit with the sheriff down in Clayton County, Victor Hill, was causing serious fiscal problems for Clayton County. The county could not direct the sheriff in that case how to properly manage his affairs, how to not do certain things that wind up costing the county taxpayers literally millions of dollars. So what this bill, with this resolution would do, put coroners in the same relationship with the county commission and their lack of management control that now exists for the sheriff, probate judge, clerk of court, and tax commissioner. And to add to that, as an example, county officers are not subject to the county's personnel system. There's an exception where you can be if they choose to be, but there's no requirement that the county officers be part of the county's personnel system. There's also case law that interpreted very broadly an existing statute which says that county officers can sue the county commissioners if they're unhappy with a decision made by the commissioners. That means the taxpayers are paying for the attorneys for the county officer as well as the attorneys for the county commission or the county as a whole. This again adds another person, another position to that list of county officers that have that right. There's also been a very recent Supreme Court decision which that interpreted an existing statute which has been around for decades. It says all contracts of the county are to be written and entered on the minutes of the county to be binding. The Supreme Court in December said that doesn't apply to county officers. So now you have county officers, sheriffs, probate judges, and others that don't have to put their contracts in writing and don't have to enter it on the minutes of the county to be binding. Now you'd be adding another county official to that list that don't have to have their contracts in writing entered on the minutes. So I think it's a mistake to keep adding to that list. I guess finally, the question is who does this benefit? And I don't see any benefit to the public as a result of this. If anything, there's a benefit to the coroners.
Hang on one second. Representative, you had a question?
I do, Mr. Chair. How many counties are we talking about here, or how many coroners are in the state?
I think most every county has a coroner, as far as I know. That the coroners can tell you for sure, but I think there's a handful of counties with medical examiners, and Fulton, DeKalb, Cobb, Gwinnett, maybe Clayton. There may be a few others. Columbus, Muskogee, I think, has an ME. But so all the rest would have coroners. And I can confirm the exact numbers, I think, over here.
So well over 150, you would say, or
probably
well
around,
over 100.
around that number. They could tell you exactly the number,
Okay.
I'm sure.
Thank you, Mr. Chair.
So and lastly, I think it would, with adding them to the list of constitutional officers as defined in the Constitution, I think it does raise the question of whether or not...
Mr. Brubeck, we're getting short on time.
Yes, sir. And I just end with a request that you hold this legislation and help out the taxpayers, and appreciate your help. Thank you.
Representative Butler.
Say a command.
Can I say a command?
I think that means it's time.
I'd like to make a motion to pass.
All right. Any other questions of the members of the committee? All right. Hearing no further questions, Representative Butler has made a motion to pass. Representative Meadows has seconded. The bill has been properly moved and seconded. All those in favor, please signify by do pass on committee substitute H.R. 294, LC 284681S. Please signify by saying aye.
Aye.
Any opposed, same sign. All right. Representative Powell, 478. J. Powell. Yes, sir. If that's...
Bye, guys.
From my seat, Mr. Chairman.
Yes, sir. What does that do?
Mr. Chairman, this is House Bill 478, and what it does is it makes a requirement that municipal court judges be licensed to practice law in the state of Georgia. That's not currently a requirement of the law. And it also provides that non-lawyer judges in municipal courts will be grandfathered in until such time as they cease serving in that capacity. There are approximately 350 municipal court judges in the state of Georgia, and 87% of them are now attorneys, 13% are non-attorneys. This legislation is supported by the Municipal Court Judges Association and is also supported by the Georgia Municipal Association.
Yes, sir, Mr. Chairman. Thank you, and members of the committee. Lamar Norton with GMA. We support this bill. We've got some fine municipal court judges. They do a great job. Those will be grandfathered in, the way I understand this legislation. And then the new requirement we fully support in trying to improve our courts at the lowest level of the system. And we want better judges and better performing courts.
Thank you, Mr. Chairman. I guess it's more of a curiosity than anything. Several years ago, we had a similar situation with magistrates, and in that particular provision, we grandfathered them for 2 or 4 years or whatever, giving them time to go ahead and complete their study. And I'm just curious as to why in this particular case, just curious why the difference in that particular case. We still saw the value and the need in meeting the requirements, but we gave them a reasonable time frame to do that. In this case, we're just going to allow them to continue to sit.
I think the difference is, and I'm not familiar with exactly that legislation, but this says that they have to be attorneys, and I do not think that any non-attorney sitting municipal court judge is going to finish his studies to become an attorney, except for maybe in 1 or 2 if somebody were now attending law school, but I don't think that they would ever qualify. And so we don't want to, if they've been sitting 5 or 10 years, we want to allow them to continue sitting, but as they cycle out of the process, it would have to be attorneys from now on.
And I wasn't around on that. I just know it because it affected a magistrate in our community that ultimately ended up leaving because she did not ultimately meet that requirement. And I guess I'm just, and I know in that case the point was at some point in time the person needs to be committed to fulfilling that requirement. And so in this case what you're saying is that requirement's just not that important?
Well, I'm not sure what the requirement was, but I don't think magistrate court judges now have to be attorneys, do they not? So I don't know what specific requirement you're speaking of, but this is a much more stringent requirement for somebody to be a licensed practicing member of the Georgia Bar.
Any other questions from members of the committee? Anybody else that would like to speak on this issue? Representative Meadows.
House Bill 478, LC 29, 3663, we pass. Motion to
I was just wondering, Representative Powell, are these all attorneys that sponsored this bill?
Yes. Is this another one of these? Is this another one of those full employment attorney acts?
I got you. All right. We've got a motion do pass on House Bill 478, LC 29, 3663. Is there a second? All right. Bill's been properly moved and seconded. All those in favor, please signify by saying aye. Any opposed? Same sign. Ladies and gentlemen, we're adjourned. At some point, we got 2 quick things to talk about. One of them is there is a Secretary of State's elections bill that is cleaned up language. It is out there. What's that bill number, Craig? You can 540. If you would take a look at that. We're going to need to move that at some point this week. The other thing is, Craig, be quiet. I'm talking about a committee dinner. Need to do a committee dinner. I am. You want to? All right, we'll talk about that at some point. But it is nice to have everybody together. And if you would, if there's some days that work or days that specifically don't work, if you would let us know about those, we'll try to accommodate people's schedule the best we can. Thank you. We're adjourned.